I flew home from my father's funeral to find a notification email from the patent office, congratulating my business partner on the successful filing of a patent for the exact device I'd spent 3 years designing, prototyping, and testing in our shared workshop. My name appeared nowhere on the application. I had been out of the country for 11 days, and in that specific window, he had filed paperwork claiming sole inventorship over the single, most significant project of my entire professional life. My name is Adrian, and this is the story of how the person I trusted most in my professional life chose the exact 11 days I was burying my father to quietly, deliberately steal the invention I'd spent 3 years of my life developing, and the 19-month legal battle it took to reclaim what should have always, unambiguously, been recognized as mine. I want to explain the specific nature of my invention and my working relationship with my business partner, Greg, because I think understanding both matters considerably to understanding just how calculated and devastating this particular betrayal actually became. I'd spent 3 years developing a specialized water filtration device intended for use in disaster relief situations, a project that combined my background in mechanical engineering with a genuine, deeply personal motivation stemming from volunteer work I'd done years earlier following a natural disaster that had left an entire community without access to clean water for weeks. I remember, specifically, the exact moment this project's motivation crystallized for me, standing in a temporary relief camp years earlier, watching families wait in long lines for water that had been trucked in from considerable distance, understanding, even then, that a portable, effective filtration solution could make an enormous difference in exactly this kind of crisis. That memory stayed with me throughout years of engineering training and early career work, eventually becoming the specific, personal drive behind the 3 years I spent developing this particular device. Greg and I had met roughly 4 years earlier at an industry conference, where we discovered genuinely complementary skill sets. My engineering background paired well with his business development and manufacturing logistics expertise. We formed a loose professional partnership, initially collaborating on smaller projects before I began developing this specific filtration device roughly 3 years ago, with Greg providing manufacturing consultation, occasional funding for prototype materials, and general business guidance throughout the development process. I want to be direct about the specific legal and professional arrangement Greg and I had established regarding this particular invention, because I think this matters enormously to understanding just how clear-cut the eventual patent theft actually was. We had, roughly 18 months into the device's development, formalized a written partnership agreement specifically addressing this project, an agreement that clearly designated me as the sole inventor, with Greg holding a defined percentage stake in any resulting commercial revenue in exchange for his manufacturing and business development contributions, but explicitly, unambiguously establishing that any resulting patent would list me, and only me, as the inventor of record. I want to describe the specific circumstances of my father's death and the resulting funeral trip, because the precise timing ultimately proved central to understanding exactly how and why Greg apparently decided this particular window represented his opportunity. My father passed away somewhat suddenly, requiring me to travel to his home country overseas for both immediate family obligations and the funeral itself, a trip that ultimately kept me away from my normal work and communication routines for 11 consecutive days, including several days with genuinely limited internet access given the specific rural location where my extended family lived. I want to describe the specific, practical arrangement Greg and I had discussed before my departure, understanding I would be largely unreachable during this period. We had, roughly 2 weeks before my father's death, actually been in the final stages of preparing our patent application together, working through the detailed technical documentation and legal paperwork required for formal filing, a process we'd been managing collaboratively, with both our names appearing on the working drafts we developed together with our patent attorney. I remember explicitly discussing with Greg, before my departure for the funeral, that we should simply pause the final filing process until my return, understanding that finalizing something this significant deserved my full attention and participation rather than being rushed through during a period when I was dealing with genuine, profound grief and limited communication access. I want to describe the actual, devastating discovery that awaited me upon returning from this 11-day trip, checking my email for the first time with reliable internet access, finding a notification from the patent office congratulating Gregory Hendricks on the successful filing and provisional acceptance of a patent application for what was, unmistakably, unambiguously, the exact filtration device I had spent 3 years designing and developing. I want to try to describe the specific, vertiginous shock of this discovery, arriving home exhausted and grieving from my father's funeral, only to find that during the exact window I'd been unreachable, dealing with profound personal loss. My business partner had apparently taken our nearly complete joint application, removed my name entirely, and filed it under his sole ownership. I called Greg immediately, my hands shaking with a combination of exhaustion, grief, and rapidly building horror as I tried to process what I was seeing. He didn't answer. I called 4 more times over the following hour, each call going straight to voicemail. Before he finally called back, his voice carrying a strange, rehearsed calm that immediately told me whatever explanation followed wouldn't be the reassuring correction I desperately needed. "Adrian, I can explain this," he said, before I'd even fully articulated my devastating discovery. "I know the timing looks bad, but there were real, legitimate business reasons for filing when I did." I remember standing in my kitchen during this call, still in the same clothes I'd traveled home in, my father's funeral only days behind me, trying to process this additional, entirely unexpected crisis on top of grief I hadn't even begun to properly work through. "You knew I was unreachable, Greg. You knew exactly when I'd be back. Why wouldn't you just wait for more days?" "I told you, there was competitive pressure," he said, his explanation sounding increasingly rehearsed with each repetition. I made a judgment call I thought was protecting both of us. I want to describe the following exhausting conversation, Greg attempting to justify this decision through a series of business rationalizations that grew increasingly implausible as I pressed for specific details that simply couldn't be reconciled with the clear, unambiguous partnership agreement we'd established specifically to prevent exactly this kind of unilateral action. Greg's explanation centered on a claim that he'd received information, during my absence, about a competing company potentially developing a similar device, creating what he characterized as urgent time pressure requiring immediate filing rather than waiting for my return from the funeral. He claimed he'd made what he described as a difficult, but ultimately necessary business decision to protect our shared invention from this competitive threat, and that he'd always intended to formally amend the patent to include my name as co-inventor once I returned. I want to try to describe the specific, sickening quality of this explanation, understanding that even if the competitive threat Greg described was genuinely real, nothing about that circumstance actually required or justified removing my name entirely from the application, rather than simply filing under both our names as originally planned, or, at minimum, immediately contacting me to discuss the situation despite my limited availability, rather than unilaterally deciding to file without me and without my name included at all. I consulted with a patent attorney roughly 3 days after this devastating discovery, a careful, experienced woman named Ms. Kowalski who specialized specifically in intellectual property disputes. Understanding I needed clear, informed guidance about what legal options actually existed to address what appeared to be a calculated, deliberate theft of my own invention. "This is actually a relatively clear-cut case," Ms. Kowalski explained during our initial consultation, after reviewing both our original partnership agreement and the actual filed patent application. "Your original agreement explicitly, unambiguously establishes you as the sole inventor. Greg's filing directly contradicts a legally binding agreement you both signed. This isn't a gray area regarding contribution or collaborative development. This is straightforward inventorship fraud, and we have strong documentation supporting your position." I want to describe the following exhausting legal process, involving formal challenges to the patent application through the Patent Office's own correction procedures, alongside separate civil legal action against Greg for breach of our partnership agreement and the underlying fraud involved in his unilateral, unauthorized filing. I want to describe the specific, additional complexity this situation introduced, understanding that patent applications, once filed, exist in a specific administrative and legal process that doesn't simply allow for immediate, easy correction, even in cases involving relatively clear evidence of fraudulent inventorship claims. The Patent Office's own correction process required extensive documentation demonstrating the actual, accurate inventorship history, including our original development notes, prototype testing records, and the detailed technical documentation I'd maintained throughout the 3-year development process, all of which, fortunately, I had preserved extensively given my own methodical approach to documenting the engineering process throughout this entire project. I want to describe the specific, difficult months that followed, navigating both the formal Patent Office correction process and the separate civil litigation against Greg, all while simultaneously still processing the genuine, profound grief of my father's recent death. A grief that this entire professional betrayal significantly compounded and complicated throughout what should have already been an incredibly difficult period. I want to describe the specific, revealing discovery that emerged during the civil litigation's discovery process, When Ms. Kowalski's investigation uncovered email communications between Greg and a potential investor, dated during the exact period of my father's funeral, discussing the patent filing in terms that directly contradicted his claimed urgency regarding a competing company, instead revealing what appeared to be a calculated decision to secure sole ownership specifically because he understood I was unreachable and unable to immediately object or intervene. I want to try to describe the specific, additional layer of devastation this discovery introduced, understanding that Greg's claimed justification about protecting our invention from competitive threat had apparently been, at least in significant part, a fabricated rationalization constructed after the fact, rather than the genuine, urgent business necessity he'd initially presented to me. The civil litigation ultimately concluded roughly 14 months after this initial discovery, resulting in a court-ordered correction of the patent's inventorship records, formally establishing me as the sole inventor as our original partnership agreement had always specified, alongside a separate financial judgment against Greg for breach of contract and the emotional distress this deliberate, calculated theft had caused during an already profoundly difficult period of grief and loss. I want to describe the specific, ongoing complexity of processing this particular betrayal, understanding that Greg's decision to exploit the exact window of my father's funeral represented not simply an opportunistic business decision, but a calculated choice to take advantage of my most vulnerable, distracted period specifically because he understood I would be unable to immediately object or intervene. I want to describe my own difficult process of determining how to move forward professionally following this legal resolution, understanding that our business partnership was, obviously, completely and permanently dissolved by this experience, requiring me to essentially rebuild my professional path forward without the manufacturing and business development expertise Greg had originally provided throughout our partnership. I've since successfully brought my filtration device to market. Working with new manufacturing partners and business advisors I've approached with considerably more caution and formal legal protection than I extended to Greg throughout our original partnership, understanding, in a way I genuinely didn't before this experience, how quickly even a seemingly solid professional partnership can reveal itself capable of calculated, opportunistic betrayal when circumstances present what someone perceives as a viable opportunity. I want to describe the specific, complicated satisfaction of eventually seeing my device successfully deployed in actual disaster relief situations, understanding that despite everything Greg attempted to take from me during my father's funeral, the actual purpose and impact of my 3 years of development work ultimately proceeded largely as I'd always intended, even though the professional path to that outcome required considerably more struggle and legal battle than should have ever been necessary. It's been just over 2 years since that devastating patent office notification first revealed Greg's betrayal. I think, often, about the specific cruelty of the timing he chose, understanding that he apparently made a calculated decision to exploit the exact period I was least capable of defending my own interests, burying my father in a country thousands of miles away, rather than waiting even a few additional days for my return, or, at minimum, attempting to reach me directly about whatever genuine business pressure he claimed to be responding to. If you've ever discovered that a trusted professional partner had deliberately exploited a moment of genuine personal vulnerability or absence to claim credit for or steal something you'd spent years developing, I want to hear how you navigated both the practical legal recovery process and the deeper question of professional trust this kind of calculated betrayal inevitably raises. I used to believe that a formal, legally binding partnership agreement, explicitly establishing clear terms regarding inventorship and ownership, represented sufficient protection against exactly this kind of unilateral, opportunistic action by a business partner. I've learned, in the most disorienting way possible, that even clear legal documentation doesn't fully protect against someone determined enough to exploit a moment of genuine vulnerability, and that sometimes the people we trust most completely with our professional collaboration are exactly the ones capable of the most calculated betrayal when they believe circumstances have created a viable opportunity to take something that was never actually theirs to claim.